If you and your spouse decide to get divorced, what happens to inheritance that you've received or likely to receive in the near future, or assets you owned before you got married? Will these automatically be split between the two of you? I'm talking now to family solicitor Julia Robson to find out how they fit into the financial agreement element of a divorce. So, Julia, is it a done deal then that everything you own is split down the middle when you get divorced?
There's no straightforward answer to that question because this is a very grey, discretionary area of the law. There's basically a 3-step process which a specialist family lawyer would undertake when first instructed by a client who is undergoing the divorce process or within the divorce process. First of all, it's really important to identify and value all of the assets, so that we can then determine what falls to be divided within what we would call the matrimonial pot. We then have to look at other factors, such as the length of the marriage, the ages of the parties, first consideration being the welfare of any minor children of the relationship or the family. Then it's a balancing act to see what would be a fair and reasonable outcome for both parties by balancing the needs and resources of those parties. So as you can see from that, it's not black and white.
Sure. What sort of assets might be referred to as pre-marital?
They would be assets, for example, acquired prior to the marriage. So that could be a house that you owned before you got married. It could be a business. You could be a farm owner, and you could have acquired those assets and had those assets before you got married.
Is it fair that an inheritance already received by one person is divided between both parties?
The question of fairness, I would put in a slightly different context following on from that question. The courts, and indeed family lawyers who are negotiating a financial settlement, will always strive to achieve a fair outcome for both parties, because at the end of the day, that is the basis upon which the court would approach any final financial order and determine the financial issues. If you are in a situation where you have inherited wealth or premarital wealth, then if it's possible for the parties' needs, I've talked earlier about needs and resources, coming back to that, if it's possible for those needs to be met without actually attacking, if you like, or utilising the premarital wealth or inherited wealth, which was inherited during the marriage, then it may be possible to ring-fence those assets. If it's not possible to meet those needs, then it may be necessary to utilise those assets.
What happens when one of the divorcing couple is going to receive a large inheritance in the future?
This is a difficult area because we as family lawyers would look to see whether that inheritance, and as indeed the court would, was foreseeable. So that means, is it likely that that person is going to receive that inheritance? And you could argue that no inheritance is ever really foreseeable because a will can be changed right up to the date of death. So from that perspective, you cannot tell whether someone is definitely going to inherit. But there's a different situation where someone has died and someone stands to inherit a sum of money and perhaps, for example, hasn't received it because of the probate process. So those would be the two differences in terms of being able to bring that inheritance into financial negotiations. And it is a case of looking at future. It's one of the factors that the court would look at, is looking at current and future needs and current and future resources.
So is it possible to ring-fence an inherited or premarital asset?
There are ways to make such an asset less likely to fall within the matrimonial pot for division upon separation and within divorce proceedings. For example, if you were to inherit some money and it went into a share portfolio and that share portfolio was kept separate and apart from any joint assets, then that would then assist in attempting to argue within negotiations that that asset should be ring-fenced. But it does also depend on length of the marriage. So for example, if it was a short marriage and the inherited wealth had been kept separate, it would be much easier to identify and possibly ring-fence. But if you had a situation where a person inherited wealth and, for example, utilised it to buy a family home or pay off a mortgage, and then it was a long marriage, it could be argued then that that inherited wealth had mingled with the other assets and therefore should be within the matrimonial pot and available for division between the parties. It is also possible to think about possible prenuptial and postnuptial agreements. Very important to get early specialist advice from the outset about that, and inherited wealth or premarital property can be protected within the terms of those agreements.
Fantastic, thank you. And my final question, what is the best way to approach such a situation if you do press on with a divorce?
Definitely seek specialist family law advice from the outset. It is so important because it's such a discretionary area of the law that you get the right advice from the outset and that you're supported within that process to enable a fair outcome to be achieved for both parties.
Julia, thank you so much for your time today. As Julia has explained, divorces that involve inherited assets can be complex and each situation is unique, so it is crucial that you seek experienced specialist advice to help find the right outcome for you and your family.